You're live.
This is House Education on April 24th. We are working through S227. We have a new version posted for folks to look at, which I would say, hang on a second, let me just do a little quick text. We have done some work. Jana and Aaron worked with one of the stakeholders here. Nothing real substantive changing, but just some clarifying about policy versus procedure and some language changes. But we'll walk through it and highlight those and hopefully be ready for a vote.
It's also just organized differently, so it looks like more changes, I think, than it is, but trying to sort of flow a little bit more the order of operations in school settings.
All right. All yours, Rick.
All right, good morning, everyone. Rick Segal with the Office of Legislative Counsel. And I appreciate the lead in because I was going to start with that there's quite a bit of yellow on this indicating changes. And it's not a dramatic change as far as the intent or the language goes, but there has been some restructuring. And there were some times where I could not highlight the yellow because I'll explain. It's otherwise the whole document's going to be yellow. So there are no changes to the first page. I can tell you that purpose stays the same, and we are still on the same chapter and section in Title 16. Okay, on page 2 in the definitions, no change to law enforcement officer. In number 2, non-public area of school, there is a little change here. The previous version used the phrase used the phrase school administrator. So you're going to see that phrase highlighted all throughout the bill because what's happened is that term school administrator, which to my understanding there was some confusion about that potentially meaning something else in Title 16. So that phrase has been removed from the bill, replaced with superintendent or head of school, and sometimes, like in this case, designee. So the previous version had just the school administrator. This committee indicated, well, what if the superintendent wants to designate a principal or some other staff member at a school to be the designee to authorize a non-public area? Well, now it's the superintendent, head of school, or one of their designees can determine a part of a school to be non-public.
Any grammar questions?
Yes.
The or designee applies to both
Yes.
superintendent or head of school. Okay.
Just went through that. I had the same thought.
I know, it's like,
There's a
did you say it
Yep.
twice? Okay,
Yep.
thanks.
Yeah, of course. That's a good question. No change to the definition of school. However, subsection B is highlighted because the definition of school administrator was removed right above that. So you had number 4, school administrator. That's been removed because we don't use that phrase in this building. Okay, in subsection B, adding the words and support, I just thought because of how this has been restructured, I think that phrase is helpful. It's going to be resources and how the school can support students. Subsection A is not new language. It is kind of rephrasing what the AG is going to do. So I will read it because it's all yellow. So a superintendent or head of school, previously it said a school administrator, shall distribute the immigration resource guide developed by the AG pursuant to subdivision 2, which we'll get to in a second, to staff, students, and family members of students. So the previous version said, that a school administrator shall distribute immigration and civil rights related resources, et cetera, that are provided by the AG. The stakeholders kind of indicated this is a more direct way to do it. I agree, actually. This is very clear that they shall distribute this guide that is developed by the AG. It's just a clear, this is what's going to happen. In B, again, administrator replaced by superintendent or head of school twice. There were the changes there. In C, adding, this is restructured more than it looks actually. So I want to spend a little bit of time here on C. So previously, the language said provide support as it starts here to the greatest extent possible. That doesn't change. To a student with regard to immigration related concerns. including, and the previous version had a colon and then it had two things that included. Those two things were, as you see there, including connecting the student and the student's family with an immigration advocacy institution. That was in the draft. So you may remember the second subdivision was providing the student with access to mental health professionals. And that was a little bit vague and like how can rural schools do that? Like, can every school actually provide that access? It was unclear. So the compromise language here, and this is maybe up for debate, is the phrase "and similar resources," which could include mental health professionals. It could also include other therapeutic things for the student to be successful in school. So again, it's up to you all what you think about that phrase and if that's appropriate or not. I can keep going.
Yeah, but it seems okay. Doesn't hold the superintendent to provide
Right.
anything in addition to what is listed here, but allows them to.
And even the immigration institute, it's still to the greatest extent possible.
Right.
So it could be that they just can't because it's all right. So 2A is the same. Let me hold on and see here, make sure I'm looking up the. So this is okay. This is what happened. So the 2A was in session law, which for newer members, session law is law, but it's used for more temporary appropriations. I'm looking at you because I know you're new. It's used for appropriations. It's used for studies, reports. The conversation made me realize that this guide is an ongoing obligation. The AG will look at this every year, and because immigration changes, immigration laws change every year. They could change every year. The way they're executed change every year. So this section, the words have not changed. However, this was in session law. Now it is in statute, which means you can find it in the green books. Easier to find for the AG and kind of more permanent. The AG, in consultation with the AOE, shall develop this guide that was referenced earlier in the statute. And again, no other changes. It's just moving it to the statute. They shall review the guide at least once annually and send any updates made. I just added that I thought made was missing. Made to the guide to all superintendents and heads of schools not later than 30 days after completing the guide. So again, that replacing that phrase. The editors did ask if it should be head.
Right, I was having the same question, yeah.
So it was a question mark, so it's kind of up to you all. It's apparently grammatically fine this way, but it's also fine if you want to say heads of school. This is the way I thought it made sense, but I don't frankly know this area well enough to how that's used.
I mean, is that gonna come up and be an issue?
No. But for those of us who are sort of particular about grammar, I'm like, heads of school or heads of schools? Yeah.
Yeah.
I think, as Rick said, either one probably is just fine.
If the editors don't have that means it's kind of, there's not a clear way of doing that. Okay, I think it's used a couple of times, so I would just be consistent. Subsection C, student information privacy, no change to C1 or C2 or C3. So no change to subsection C. This is the record keeping, not sharing information unless required by federal law. Okay, on page 4, bottom of page 3, subsection 4. Now I'm on page 4, sorry. I'm having multiple sheets of paper. Just the change from school administrator to superintendent or head of school 3 times. This is the law enforcement section. So now it's the same thing, just worded differently. On page 5, again, superintendent or head of school. No change to 2, 3, or 4. So there was a subdivision 5 on page 5 that was removed. And this was the provision that had the schools create procedures for law enforcement on site. And this language was partially moved to a different part of the bill. So it's not gone, but it did have language in there that I can read it to you all, that AOE shall develop model procedures to implement the law enforcement section. And again, stakeholder had questions about, well, the policy is always above the procedures. So the way the bill is kind of structured, we would like that language to be later in the bill. So I was like, that's fine. It's still the same language, it's just moved a little bit later. There is one thing that was removed that I'll mention here in a second. And that's why E is highlighted, because 5 was deleted. Okay, on the next page, page 6, we are in this immigration agreement section. Replacing, school administrator with superintendent or head of school. Applicability, no change, that federal law cannot be preempted by this law. Okay, so policy required. The model policy is still required, that AOE has to develop its model policy. The change, and this is where the subdivision 5 would come in a little bit, because here you have, instead of set forth in this section, so the policy is now just going to be subsections C and D, which are the law enforcement section and the, make sure I get this correct, the student information section. And the thought was there that the model policy does not even include details about the immigration agreements, does not need to include information about the immigration resource guide. The policy is just really about how you share information and how law enforcement, when they appear on site, if they do, how that should be developed in policy. So it's making their job easier. AOE's job is the policy is going to be more narrow to just certain parts of the bill. I didn't have a problem with it.
And that's because the other part, like distributing the resource guide, is in statute.
Right.
We don't need to have a policy.
Right. There's no really, and I thought about this. When I was in the meeting, I was like, yeah, let me think about this. And I thought about it. I don't see any issue, and we can disagree, but I don't see any legal issue with having it limited to just those two parts of the bill. Okay. In the adoption of the policy, so again, the schools must adopt a policy that's at least as stringent as the model policy. If they don't adopt it, they adopt the model policy by default. So these sentences at the ends of A and B, A is for public schools, B is for independent schools, this is the administrative procedures. And this is new. And this was also taken from subdivision 5 that was deleted, that says that, you have these policies that are developed, but then at the local level, at the school level, you have to have procedures that carry out these policies that are adopted. That specific language was missing, and that was recommended to help schools figure out a path to actually make this work in reality. And I don't know if this works. I think this gets the point across, but I'll be curious what you all think about that language.
It's pretty typical. I mean, if you sort of go through the hierarchy of AOE develops a model policy, school boards adopt the policy, superintendents create the procedures and protocols around those policies.
But I did talk with Chelsea from the Vermont Homeless this morning, because they've been helpful in helping figure out how this would apply in the real world. And given the sort of different nature of this whole topic area, superintendents felt like we should develop model procedures in this case as well. So I don't know how big of a directing change that would be, but
Probably not major if it's just going to be, you would put it up in B or in G1. You would say a model policy along with procedures, something like that. Yeah, not a huge, if that's what the committee wants. And then I would delete. Do they adopt procedures too? Do schools adopt procedures? How does that work when AOE, if AOE adopt the procedure, a model procedure, how does that work in reality?
I don't know if they ever adopt procedures on any side, whether whoever comes.
So maybe the AOE is making a recommendation for model recommended procedures, yeah.
Question about whether we just develop model. That's really administrative, what the procedures are in my experience.
Right. What I'm hearing you say is that their concern is that this is a sensitive topic area, and rather than everybody going off in their own direction.
I really do. And yeah. And it would be very helpful if it were consistent.
Right.
I think that's consistent, and I'm sure that's why that's at this starting on this, but I.
Yeah.
I just had a question on on page 7, line 13, any approved independent school that fails to adopt a policy shall be presumed to have adopted the most current model policy. So as you said, the head of school actually develops the procedures, but I guess my question is, what happens if an independent school, if that presumption is wrong and they haven't adopted this policy and they're ignoring this law? And also, like, should we assume that there are any independent schools that would actually be against this law? From what I understand, most schools want this to work.
Right. I think, so the answer to your question is, there is no policy police out there
Right.
for either independent schools or public schools. Both sort of have their enforcement mechanism. If you want to play the scenario all the way out, that a school that refuses to adopt required policy, from a public school point of view, could be closed by the secretary, and from an independent school could lose their ability to receive public tuition.
Right, okay, so they would no longer be an approved independent school.
I'm concerned about asking in any particular case to go and ask the AOE to develop procedures if we never do that. If the sort of the system that we operate under is they have a policy and it's superintendents who do procedures, I don't want to change that in this particular instance. I would leave it as it is. For what it's worth.
Go ahead.
I was just gonna say, that was my gut reaction as well, but your suggestion, Chair Conlon, about developing recommended
Recommended.
procedures would make me feel more comfortable because they're not required, they're recommended, and I do think there's some value in the sensitivity of the topic and the consistency of procedures following the policy. But I don't, I could think I could be wrong, but I've never seen model procedures.
I don't know.
I just don't know. In law, I mean,
I believe it exists in the behavior threat assessment.
does it?
Yep.
So is the situation that each school may have, because they're uniquely built and designed and potentially structured, that a model procedure would not be appropriate? Is that possible? Is that why? I don't know if the language here, they see on the screen, this allows each superintendent to, based on their school and their staff, I don't know. I'm just, if the AOE recommends procedures, I guess they can ignore those recommendations. I guess that's the way it'd be worded, is that they would just be recommended. They wouldn't be, I don't even want to say model.
Right.
I'm just kind of thinking about how this would actually work.
But let's go back up, because it only applies to section A.
Yes.
Which is. Well, actually.
Well, this is,
Yeah.
this is still about the law enforcement on site and the student privacy.
Yeah.
So this is still, it's flowing, and I'm going back to my meeting yesterday, it flows from the policy, right? The district has the policy from AOE that suggests the STEMOL policy, and the procedures flow down from that. So I just want to be how prescriptive you want to be when it comes to procedures. Bless you.
Are people good with language that would sort of provide recommended procedures as opposed to required procedures?
I was gonna say, the behavior threat, do you have that language? Working on this?
I haven't taken a look. Exactly.
You said.
I have not pulled that actual language, no, but I mean, in starting to prepare for all of this, this is actually, this is a school safety, I mean, it's being put in the school safety chapter and, so this all ties together. But so there is precedent for that, but I think recommended procedures, I just think some consistency yeah, is important and is not new or unique in this area of safety.
When I also agree, this is sort of so outside the, sort of the training of a superintendent.
Yeah.
That I think, some recommended procedures would be good.
Yeah, let's do that. Thank you for that.
And type that up once we complete the. Okay, I see you want to vote on this morning.
Yes.
Okay, I have until 10, so.
Oh, great.
That's my schedule. All right, and then on page 7, I already talked about, do you want to keep do you want to reference the model recommended procedures, or do you just want to leave it at that, they shall develop procedures?
I think we would probably, I'm not sure if we would need that sentence.
Would you say
Yeah.
it shall
Because it's-
implement,
Well, I think I would say maybe in the top part would be recommended procedures for superintendents or something that.
In the AOE's task,
Correct. Coming up with
And-
policy, model policy and recommended procedures. Well, I guess those are two separate places, but
Yeah.
but you don't want to require them to adopt procedures.
that's right.
Okay.
is he still required to implement the procedures though?
Yeah,
So do you want to not get rid of that?
I'm not sure you have to state that
No, that's fine.
superintendents implement procedures because that's what
Yeah,
that's just what
I-
they do.
I mean, I'm okay getting rid of the sentence, I just want to make sure we're not.
Because they're only gonna develop or adopt. Right? They would either develop their own procedures or utilizing the recommended template, we can just adopt that template.
Okay, or not have any procedures.
Yeah.
And right, if you're so that's fine. I just don't know how common that would be. Okay, so I'll strike those two yellow.
It's always understood that when a
Yeah.
policy is adopted, a superintendent adjusts the procedures.
So I'll strike those two sentences in the next edit. All right, in section 3, this again existed, but because we moved most of the language, the immigration resource guide into statute, this is just now the deadline. And I do want to talk a little bit about the deadline. It's been August 1 of this year. And then they shall send the guide to superintendents and heads of schools by August 31. The effective date is July 1. So you give them a month and maybe they're ready to go. I don't know if Julio Thompson or anyone else has testified as to if they're working on this already, maybe they are. But maybe consider either on passage or pushing out the date a little bit.
What do we do on passage?
Passage.
Yeah, I'm going to speculate with some confidence that they probably could turn this around and
Yeah.
very, very quickly.
Question on this that maybe was answered and I missed it because it came up, I think, very early when we looked at this bill that normally is the procedure, policy, whatever, that things go to the AOE and then distribute down to superintendents and then distribute down to school. So this is going directly to the superintendents and not going to the AOE first to be distributed to their network. So I think someone brought that up as a
Yes,
question.
somebody
Of
did.
the AG.
That was brought
Should the
out.
AG send it to superintendents or to the Agency of Education? In most cases, goes to AOE, it's the one who then
And
distributes.
we're actually somewhat silent on that.
Well, it says it shall send it to the superintendents of schools. Should the AG have to do that or just go to AO, just to the AOE and then have them do it? Through their network that they use for everything else. The AG having to go to 52
So-
superintendents, find all the independent schools, make sure they all have it.
Yes.
Sorry, I restructured. I was reading as you were talking. So
It seems overly complicated on the AG's office to do that.
in statute is in consultation. So that's the extent of the distribution. So you work with AOE, the AG works with AOE, but then the distribution steps around AOE. So if you want to change that, we can.
I think the AG should
For distribution.
for distribution, because they already have a distribution network for
Yeah.
everything else in place. So.
Makes sense. I
Yeah.
guess, Yeah.
I think that's.
So the AG still develops it. with
Yes.
With
AOE,
consultation.
when the AOE distributes it. Okay.
Okay, so just to summarize, we've asked legislative council to go back and have AOE come up with recommended procedures. And we have asked to have the distribution channel for what the AG develops go through AOE for distribution, which does make sense. They're the ones who've got the contact information. Yes, Leo.
Question on page 3. We had said immigration advocacy institution and similar resources. I'm wondering, do we want both, or do we want, if immigration advocacy institution isn't there, we would then want similar resources? Do we want both, or do you want one or similar if one isn't available?
Immigration advocacy institution. I guess and. The really question is whether you go with and or.
Yeah, we want to have
Or,
and that, or if one's not available, then do the other.
I think if you have or, you could limit it to something similar. And is broad and allows a lot more.
So it wouldn't necessarily mean that you'd have to do both.
That's right.
Okay.
Because it always says to the extent possible. All right,
We go over what you want me to do, or do you want to go over what you want me to do?
so again, it would just be the two that we just talked about, having the distribution from the AG go through AOE, and then AOE coming up with recommended procedures.
And removing those two sentences that the superintendent head of school shall
Yeah.
develop and implement procedures. Okay. And the effective date.
Mhm.
Okay,
You need,
10 minutes?
great, that'd be great, thank you.
Nice.
All right, everybody, we will, rather than putting everybody on silent, we will just